Federal courts are turning on gun laws. And that's not an exaggeration, it's a pattern. Across the country, judges are increasingly blocking, freezing, or striking down firearm regulations that just a few years ago would have likely survived without much resistance. Laws passed by legislatures, rules issued by agencies, and enforcement policies once considered settled are now facing serious pushback in court. And the shift is happening quietly. There hasn't been one single ruling that changed everything overnight. Instead, this has been building case by case, court by court, as judges apply a very different legal framework than they did in the past. So today, we're going to explain what's really happening, why federal courts are responding this way, and what this trend means going forward, not just for gun owners, but for lawmakers, regulators, and the entire legal system. Because when federal courts start pushing back on gun laws, it signals something much bigger than any single case. For decades, gun regulation followed a fairly predictable path through the courts. Legislatures passed laws, agencies enforced them, and courts generally deferred to lawmakers and regulators unless a law was especially extreme. That deference came from a legal approach that allowed judges to weigh government interests against individual rights. If a court believed a regulation served public safety and wasn't too burdensome, it often survived. But that approach is no longer controlling. The legal foundation supporting many modern gun laws has shifted, and federal courts are now required to analyze firearm regulations through a much stricter lens. That change comes primarily from the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. Bruin fundamentally altered how courts evaluate gun laws. Instead of balancing tests or policy judgments, courts must now ask a very specific question. Is the regulation consistent with the nation's historical tradition of firearm regulation? If the government cannot show that a modern gun law has a meaningful historical analog dating back to the founding era or early American history, the law is constitutionally suspect. That is a much higher bar, and it's one that many gun laws are failing to clear. As federal judges apply this framework, they're finding that large portions of modern firearms regulation simply don't have historical equivalents. Licensing schemes, carry restrictions, possession limits, and enforcement mechanisms that emerged in the 20th century often lack roots in early American law. When courts reach that conclusion, they don't have much discretion. Under Bruin, the analysis stops there. And that's why we're seeing federal courts step in more frequently. This doesn't mean judges are suddenly becoming activists or partisan actors. In fact, many of these rulings come from judges across the ideological spectrum. What's changed isn't the judges. It's the rules they're required to follow. Federal courts are no longer permitted to uphold gun laws based on modern policy preferences or statistical arguments alone. Historical consistency is now the deciding factor. Another major reason courts are turning on gun laws involves agency power. Many firearm regulations are not passed directly by Congress. Instead, they are created or expanded through administrative agencies, most notably the Bureau of Alcohol, Tobacco, Firearms, and Explosives. For years, agencies enjoyed broad deference when interpreting statutes. Courts often allowed regulators to fill in gaps, define ambiguous terms, and issue binding rules. But that deference is eroding. Federal courts are increasingly skeptical of agencies that attempt to create new obligations or criminal penalties without clear authorization from Congress. When a regulation affects constitutional rights, and especially when it carries criminal consequences, judges are demanding far more precision. They're asking whether Congress explicitly authorized the agency to act. They're questioning whether an agency can redefine statutory terms. And they're pushing back when regulators appear to be making policy rather than enforcing law. In gun cases, that skepticism has real consequences. Courts have blocked rules, narrowed enforcement, and questioned long-standing interpretations that agencies relied on for decades. This is part of a broader shift in administrative law, but it hits gun regulation particularly hard because of the constitutional issues involved. Another factor driving this trend is litigation volume. Gun laws are being challenged more aggressively and more strategically than ever before. Well-funded legal challenges, coordinated lawsuits, and carefully selected test cases are putting pressure on courts to address these issues head-on. as more cases reach federal judges, inconsistencies emerge. Courts compare notes, rulings from one district influence another, and patterns begin to form. That's how trends in the law develop. And right now, the trend is unmistakable. Federal courts are scrutinizing gun laws more closely. They are less willing to defer, and they are more willing to block enforcement when constitutional questions remain unresolved. So what does this look like in practice? It often begins with an injunction. A judge reviews a challenged law or regulation and concludes that it is likely unconstitutional under the current legal framework. Rather than allowing enforcement to continue while the case drags on, the court freezes the law. That means no arrests under that statute, no prosecutions based on that rule, no penalties while the case proceeds. These injunctions can last months or even years. And even if they are eventually overturned, they disrupt enforcement and force governments to reconsider their strategies. In some cases, courts issue narrow rulings limited to specific plaintiffs. In others, they issue broader orders that affect entire states or even nationwide enforcement. Either way, the message is clear. The courts are no longer rubber-stamping gun regulations. For lawmakers, this creates a dilemma. Passing gun laws that satisfy the Bruin framework is difficult. Legislatures must now consider historical analogs, constitutional constraints, and enforcement limits in ways they didn't before. Many modern policy ideas simply don't translate well into that framework. As a result, lawmakers face increased legal risk when drafting firearm legislation. Laws that sound reasonable in theory may not survive judicial scrutiny. For regulators, the challenge is even greater. Agencies like the ATF are being told, implicitly and explicitly, that they cannot legislate through regulation. They must operate within narrow statutory boundaries, and even then, their actions are subject to strict constitutional review. This limits flexibility. It also increases litigation risk. And it means that enforcement strategies that once seemed routine now carry significant legal exposure. For gun owners and businesses, the situation is mixed. On one hand, increased judicial scrutiny offers protection against sudden regulatory changes. Courts are acting as a check on overreach. On the other hand, uncertainty creates risk. A law may be blocked today and reinstated tomorrow. Enforcement priorities may shift. Compliance decisions become harder. That's why understanding the legal process matters. Federal court rulings don't exist in a vacuum. They move through appeals. They interact with other cases, and they can change quickly. It's also important to understand that this trend doesn't mean all gun laws are doomed. Courts are not eliminating regulation altogether. They are requiring justification. Laws with strong historical foundations are more likely to survive. Regulations that closely mirror early American practices stand on firmer ground. But laws that rely on modern policy arguments without historical support are increasingly vulnerable. That's the dividing line. Looking ahead, there are several things to watch. First, appellate courts. District court rulings matter, but appellate decisions shape broader precedent. How circuit courts handle these cases will determine whether this trend accelerates or stabilizes. Second, Supreme Court involvement. The Supreme Court doesn't need to issue sweeping rulings to influence outcomes. Even declining to hear certain cases can signal approval or disapproval of lower court decisions. Third, legislative responses. Congress and state legislatures may attempt to rewrite laws to fit within constitutional boundaries. Some will succeed. Others will fail. And finally, enforcement behavior. Agencies adapt. When courts push back, regulators change tactics. Watching how enforcement priorities shift can provide insight into what's coming next. So when people say federal courts are turning on gun laws, they're really describing a deeper transformation. A transformation in how rights are analyzed, a transformation in how agency power is viewed, and a transformation in how constitutional limits are enforced. This isn't about one judge or one case. It's about a system recalibrating after years of expansion. That process is slow, it's uneven, and it's often confusing, but it's real. And it's reshaping the future of gun law in the United States. The key takeaway is this: Federal courts are no longer assuming gun regulations are valid simply because they were passed or enforced. They are demanding justification. They are enforcing limits. And they are reminding lawmakers and regulators that constitutional rights come with real constraints. That doesn't mean the debate is over. It means it's entering a new phase. And understanding that shift is essential for anyone trying to make sense of where gun laws are headed next.